Good afternoon. I'm Chris Schroeder. I'm a co-director of the program in public law here. Away for the semester visiting at a couple places in New York and happened to be back today to do some personal business and ran into my good friend Garrett Epps, who's giving a talk for us today, and it's a delight to be able to introduce him. Garrett is the Orlando John and Marian H. Hollis Professor at the University of Oregon. In the fall, he will be relocating to this coast to join the faculty of the University of Baltimore. One influence in that decision, I'm sure, is his longtime association with Washington and this side of the country. Garrett worked as a reporter for the Washington Post before taking the law school route, which brought him here to Duke, where he graduated in 1991 after good education at a couple of other institutions that I will not put in the same sentence with Duke University. He is a prolific writer, both in law review sorts of formats as well as outlets such as the New York Times, the New York Review of Books, the American Progress, the New Republic. And he's written 4 books, two novels and 2 nonfiction books. His first of the nonfiction books, To an Unknown God, is the story of a Supreme Court decision, the story behind a Supreme Court decision called Employment Division versus Smith, which has permitted the state of Oregon to discipline a couple of state employees who were caught chewing peyote as part of a religious service. And the Supreme Court eventually upheld the state's ability against a First Amendment challenge to sanction employees using facially neutral laws of general application, despite the fact that there was a significant burdening of religious practice in that sanctioning. And it's a delightful book. I urge a great read. It's a great story, in addition to being a very important case. The characters involved are memorable on both sides of the versus sign. His most recent nonfiction book is going to be the basis of today's talk, Democracy Reborn, the 14th Amendment and the Fight for Equal Rights in Post-Civil War America. Garrett just told me that this book has just been awarded the 2008 Francis Fuller Victor Prize for General Nonfiction. And it's a delight to have him here today. I'm sure he's going to be willing to take some questions at the end of the talk, but let's first hear from Garrett and give him a nice round of applause.
Thanks, Chris. I want to start with a poem by Emily Dickinson that forms the epigraph of Democracy Reborn, and I think focuses some of what I'm trying to convey. This poem, written in 1865, is called Revolution is the Pod. Revolution is the pod systems rattle from. When the winds of will are stirred, excellent is bloom, but except its russet base, every summer be the entomber of itself, so of liberty, left inactive on the stalk, all its purple fled, revolution shakes it for test, if it be dead. Poets are our real liberty bells in this country. They pick up the vibrations of what is happening elsewhere in society and translate them, sometimes in enigmatic form, into markers, cultural markers that we neglect at our peril. If you want to understand what happened in the middle of the 19th century in this country, Walt Whitman, John Greenleaf Whittier, a number of other American poets are a really good place to start. And Emily Dickinson, whom we are taught to consider a poet of the private, the personal, the Belle of Amherst who lived her life confined by the duties of a 19th century woman, was as much a part of what happened in this country in 1865 as anybody else. She picked up that we were in the midst of a revolution in the United States, and in the midst of what I contend is the real American Revolution, the one we should consider our revolutionary heritage, not 1776 and 1787, but 1861 to 1865, and its political and constitutional sequel, 1865 to 1866, the framing of the 14th Amendment, which is the subject of Democracy Reborn. Now, I recognize this is not the paradigm, to use a fashionable word, that constitutional law is taught in, and we instead are directed to the activities of the framers in 1787. Just as a test, how many people here have ever been to the National Constitution Center in Philadelphia, which is the tourist site built next to Independence Hall, where the Constitution was actually framed? And one of the real markers of contemporary American culture is that Independence Hall is a very lovely, small Georgian brick structure, inside which is a room somewhat smaller than this one, where the actual delegates to the Philadelphia Convention wrote the Constitution. So Constitution Hall, this nice small building, is located here. Directly across the street is a building roughly twice its size that houses the Liberty Bell, because more people would really rather see this bell that only rang once than see where the Constitution was written. And then down the block from that is a building roughly 10 times the size of Independence Hall, which is the kind of tourist place where you can go and where more people go than either of the other places to see about the Constitution. And if you go to the Constitution Center, you start off by seeing a really terrific drama presented by actors who sort of represent, the framers in Philadelphia, and sort of act out this godlike moment where they sort of say, in Mickey Rooney fashion, hey, let's put on a Constitution. Great idea. We can do it in my dad's barn. No, let's do it in Independence Hall. And they assemble, they make speeches like, because of what we have done today, someday there will be an Air Force, an interstate highway, even Monday Night Football. They look far ahead into the future. And if after you leave the theater, you have to see the drama first, then after you leave, you can look at these exhibits that are up, and there's a small placard about the size, maybe twice the size of this piece of paper, that is the sole mention of what happened to the Constitution after the Civil War. And the entire discussion of the 14th Amendment is as follows. The 14th defines U.S. citizenship and includes all black Americans. Now, those of you, I hope, who have read the entire 14th Amendment, which some constitutional law students do, know that that represents the first sentence, the first 28 words of a 400-word amendment. My position is that the 14th Amendment, in fact, not only is the longest amendment to the Constitution, not only the most important amendment to the Constitution, but is, in fact, in large sense, the actual Constitution that we live under, and serves as the memorial and instantiation of the actual revolution that took place during and after the Civil War. The 14th Amendment is basically the source of most of the rights we use every day, because until the 14th Amendment, none of the guarantees of the Bill of Rights applied against state government. States were perfectly free to restrict freedom of the press, freedom of assembly, freedom of religion, and many of them did enthusiastically. The 14th Amendment bars the states from discrimination among races, between sexes, between natives and newcomers, even between citizens and aliens. Anyone born in the United States is a citizen because of the 14th Amendment. State governments must conduct elections according to the principle of one person, one vote because of the 14th Amendment. And in fact, the United States is something that we might, without blushing, call an advanced democracy because of the 14th Amendment. The key to understanding that claim is to understand that for all the brilliance of these guys in the hats and powdered wigs at Philadelphia, the Constitution that they wrote was a catastrophic failure. And I call it that not simply because it collapsed into bloody fragments 75 years after it was framed with the onset of the Civil War, producing, by the way, probably the worst war in the history of the world up to that time. But it was a failure even after it was promulgated because it never really produced what it was designed to produce, and that is one nation. Instead, it produced a sort of centrifugal confederation of incompatible states. It carried the seeds of its own destruction, and it perished on July 4th, 1864 at 1863 at Cemetery Ridge, and the new republic was born 15 days later with the assault on Battery Wagner by the 54th Massachusetts Infantry in South Carolina. What was the failure? What was the failure of the Constitution? Well, John Hart Ely, in his book Democracy and Distrust, points out that the Constitution of 1787 contained one and only one substantive political value as opposed to procedural rights. The one substantive political value in the Constitution of 1787 was absolute guarantee of slavery as a system that could be used by states of the American Union. Not only did the Constitution of 1787 preserve slavery and guarantee its existence for states that chose it, it carefully gave those states the predominant influence in the new government it set up. The chief mechanism, which I assume you've all studied, being the so-called 3/5 clause, which gave the slave states representation in Congress and in the electoral vote for 3/5 of their slave populations. That disproportionate representation meant that from the beginning, the slave states controlled the federal machine and controlled who would lead it. And by the third decade of the 19th century, Americans who were informed, North and South, agreed generally that the country was run by something that they called the slave power, that being an extremely common phrase in 19th century political thought, about as common as phrases like the intelligence community or the military-industrial complex is in our current discourse. Foreign policy, domestic policy, and politics were controlled by the slave power. When I grew up in the South, in Richmond, Virginia, a long time ago, we were taught that the war, which we called the war between the states, was fought over states' rights. And I was always a little wise guy, and I used to raise my hand and say, well, teacher, was that states' rights to have slaves? And they would explain to me, shut up. In a sense, it's true that states' rights were an important cause of the Civil War. But interestingly enough, during the 1840s and 1850s, it was the free states that were concerned with protecting their right to maintain free labor systems against the federal juggernaut. And if you read about the 1858 senatorial campaign between Lincoln and Douglas that produced the Lincoln-Douglas debates, Lincoln is the states' rights candidate in that. He keeps saying, Judge Douglas and the South is going to make Illinois a slave state. If we don't do something right away, the federal government is going to impose slavery on us. The slave power concept is the vital background for understanding what the framers of the 14th Amendment, whom I regard as the real framers of our Constitution, were doing in 1865, 1866, when they met to redo the Constitution. They knew that if they did not act fast, if they did not strike hard while they had the opportunity, the South would emerge from the Civil War not less but more politically powerful than it was before. One representative, Eben Ingersoll of Illinois, said on the floor of Congress, if we don't do something right away, quote, you will have the same old slave power, the enemy of liberty and justice, ruling this nation again, which it ruled for so many years. And in case you think that was sort of hyperbole by the North or anti-slavery radicals in order to get people riled up so they could do what they wanted, there is a quote from roughly the same period from the Richmond Examiner from my hometown, Richmond being a very famous site of really, really bad newspapers. I myself ran one once, so I can speak with authority. The Examiner, one of my favorite papers in all of American history, because it was so extreme that at one point it denounced General Robert E. Lee as a traitor to the Confederacy because he had suggested some moderate measures about slavery. In late 1865, after the Civil War, it ran the following under the headline, News from Washington. Universal assent appears to be given to the proposition that if the states lately rebellious be restored to rights of representation according to the federal basis, that's 3/5, or to the basis of numbers enlarged by the enumeration of all the blacks in the next census, the political power of the country will pass into the hands of the South, aided as it will be by Northern allies. The South claims this will be the fact, and the North does not dispute it. That pretty much describes the political situation in 1865. The situation in the country at large was no less extraordinary. It was a revolutionary situation. Half the country, or almost half, was under military occupation and martial law. In the entire country, civil liberties were not quite suspended, but they certainly were in twilight. Trials and executions were being carried out of American citizens on American soil by military commission with no formal appeal. Prisoners were being tried, shackled and hooded without the opportunity to present evidence or any meaningful appeal procedure. My favorite symbol of what the situation was like is the story of what's called the Old Capitol. The Old Capitol was the building in which Congress met after the British burned the actual Capitol in during the War of 1812. With the rebuilding of the Capitol, which was completed during the Civil War, Congress had moved back to the Capitol building. The Old Capitol survived as a boarding house. Among other people who lived there during the pre-war era was John C. Calhoun. But when he became president, Lincoln turned it into a secret prison where suspected Confederate sympathizers and spies were held secretly without trial. The Old Capitol is no longer available to be seen. However, if you go to Washington to try to find it, you'll find on the site of this former concentration camp the modern building of the United States Supreme Court. There was more in the air than simply the political chaos. There was bloody civil unrest, north and south. There were rumors of an impending military coup in Washington. There was an absolutely savage battle underway, not only between regions, but between the branches of the government. It's a little bit like 7 Days in May. On one side, representing Southern interests, representing the conservative pre-war view of the Constitution and the Union, was Andrew Johnson, the accidental president who had been put in place as a result of the failed conspiracy of Good Friday, April 1865, in which Lincoln was assassinated. It's almost impossible to believe today that someone like Andrew Johnson could become president of the United States. Just imagine someone with this personality and these traits becoming president. Couldn't happen. He was a reformed alcoholic who had stopped drinking largely by willpower, but admitted to no sort of underlying disease process. His personality was rigid, resentful, even authoritarian. He believed in unbridled executive power. He refused to share information with Congress, regarded Congress as illegitimate. He surrounded himself with cronies. If you were not completely personally loyal to him, he regarded you as an enemy. Those who disagreed with his policies, he considered traitors. He regarded any criticism as treason. You were either with him or you were with the enemy. Thank God we do not have a president of this stripe today. In a public address in 1866, he said this about the congressional leadership of his own party, the party that had put him in office. I look upon them as being fundamentally opposed to the principles of our government and as seeking to destroy it. So you can see that Johnson was prepared to take a fairly hard line and give nothing to the anti-slavery political forces that had actually run the Union during the Civil War. On the other side, opposing the most powerful president in the history of the country up to that time was the anti-slavery leadership of the 39th Congress. These are the people whose names are largely lost to history and whom we would profit, with the exception of a really excellent book, Democracy Reborn, which is available on Amazon.com. For those of you who have your laptops with you, you could order it even as we speak. A very interesting group of people who were determined to convert the United States into what they would have considered a genuine republic. These are people like Thaddeus Stevens and John Armour Bingham in the House, Charles Sumner in the Senate, people who were very outspoken in their belief that the original Constitution had been flawed since its inception and needed to be redone quite thoroughly. And just to give you one example so that we will have some time for, I could go on and on about that, but one example so that we can move on to the question period. The first draft of what became the 14th Amendment, what was called the Omnibus Amendment, was written by a man named Robert Dale Owen, probably the most famous and in many ways most feared political and social reformer in the United States at that time. He was a freethinker, an atheist, a feminist. He was the first American to write about birth control, the first American to advocate divorce. In his later years, he was an abolitionist. And to think that he was the author of the 14th Amendment, it's a little bit as if the Democratic Congress were to bring forth a new constitutional amendment now and say, we have a new amendment, we want to redo the federal system. We've made some changes for the draft, we've watered it down, but we really want to thank Bernie Sanders and Ralph Nader for writing the original proposal. It really is that radical. What are the radical ideas that underlie the 14th Amendment? I think they can be summed up in two phrases from Carl Schurz, who was a very important German immigrant, a revolutionary legend from the continent, and a very important anti-slavery thinker and politician. And the two principles that he enunciated during this period were, first of all, quote, the Republic of Equal Rights, where the title to manhood is the title to citizenship. And second, quote, a union of truly democratic states. These phrases alert us to some very important 19th century ideas about republicanism that were not in the original Constitution. A 19th century republic was radically egalitarian. There were no gradations of citizenship in a 19th century republic. No freeholders, non-freeholders, apprentices, free blacks, slaves. All Americans had citizenship, and citizenship was equal. The concept of the Republic of Equal Rights also captures the idea that membership in American society is not tribal, it is not racial, it is not ethnic. The American nationality, according to Schurz, is one based on ideas and shared allegiance to equality rather than on race or national origin. John Armour Bingham, the principal author of Section 1, believed that there were no legal ranks and that citizenship was universal, not to be withheld by the sovereign. Everyone born in society is a citizen, and the United States is not a collection of states, but a nation. Bingham once said, "America must have one country, one citizenship, and one constitution." Finally, states are significant within the Union only as parts of the democratic whole. They do not have rights, they do not have sovereignty they can assert against the nation. During the debates on the 14th Amendment, James Garfield, later President of the United States, explained this idea this way. What is the meaning of the word state as applied to Ohio or Alabama? They are only geographical subdivisions of a state. They are endowed by the people of the United States with the rights of local self-government. Yet in all their external relations, their sovereignty is completely destroyed, being merged in the supreme federal government. And in case you think that was a radical outlying view, you can look at even what Andrew Johnson said. Johnson being the farthest right possible voice in the national debate. I mean, not quite Mike Huckabee, actually a little to the right of Huckabee in our current debate, who said in a message to Congress, the nation is sovereign against the states are not sovereign against the nation. The language of state sovereignty is the language of the Confederacy, not the language of the Constitution. Within the sphere that it operated, the 14th Amendment was really designed to change everything. It was designed to empower the federal government. It was designed to empower the Congress to intervene deeply in the political and social systems of the states to ensure that American society would be run by Republican rule, to ensure birthright citizenship for every person, to protect all people in the South, and make sure that an open political system evolved in the former dictatorships of the South. And finally, to protect immigrants and aliens against what John Bingham called the terrible enormity of distinguishing here in the laws between the citizen and the stranger within our gates. We all know the 14th Amendment didn't achieve those goals. A conservative Supreme Court in the last part of the 19th and early part of the 20th century leached it of its radical content. But the ideas within the 14th Amendment remain, and they inspire us to this day. Ideas are stubborn. They are as stubborn in their way as facts. Jefferson wrote the phrase, "all men are created equal," into the very birth certificate of the United States. Nearly a century later, it was those words that produced Abraham Lincoln, Frederick Douglass, John Bingham, Elizabeth Cady Stanton, Susan B. Anthony. Those words brought slavery to its knees, proclaimed liberty to the captives, and brought the Jubilee. And just so, ever since 1868, when the 14th Amendment was ratified, words like due process and equal protection have reminded us that the real makers of this country made promises to history that remain unkept. The 14th Amendment has been like yeast in a heavy mass of bread dough, slowly transforming the country. I believe that if we learned more about the second framers and less about the first, we would be able to understand the true direction of American history. I wish very much that our judges in general, and particularly the justices of the current Supreme Court, understood that the 14th Amendment, in my judgment, writes into the Constitution the values of what the 20th century Austrian philosopher Karl Popper called the open society, a society where no value, no practice, no institution, and no group are beyond challenge and critique, a society where membership is not based on race, blood, or country of origin, but on our simple shared humanity. Far too many of our states fall far short of this ideal. Far too many of our justices believe, as the nation wrote of the Old South, that, quote, the local majority is absolute. Far too many politicians choose the local majority over the open society. State sovereignty and states' rights, ideas that were buried at Gettysburg, rule us from their graves. To paraphrase Lincoln at Gettysburg, it is for us, the living, to dedicate ourselves to finishing the work the second framers began. The words of the Second Constitution are not always clear, but nonetheless, like America itself, they are a prophecy and a promise to history. Today, as in 1868, as a society and as individuals, we often hesitate in front of the radical claim of true equality. But the idea was written into the American sky by our second founders, and still it goes before us, a pillar of cloud by day, a pillar of fire by night, summons us toward a truly democratic union of truly democratic states. I think we have time for questions, and I thank you for your attention. In the back.
Thanks for your comments. Really interesting thesis. I was wondering, it seems like the language of equality has sort of been exhausted, both politically and substantively, over since the civil rights movement. Mm-hmm. And the language of liberty is sort of gaining more salience. For example, the Lawrence opinion basing its holding on the principle of liberty as opposed to equality. I'm wondering if the 14th Amendment, in your sort of research or your opinion, it embodies one principle or the other more in its inception, or as it would be imagined historically.
Well, I think that's an excellent point. And just as a cultural note, it's very important to note that since September 11th, the basic government policy has been, to quote President Bush, freedom is on the move, or freedom is on the march, or freedom is dropping cruise missiles on you, depending on the given circumstance. Not equality, not Republican self-government, and certainly not the rule of law. And I believe that all of those values, that is, rule of law, Republican self-government, and equality, are captured in the 14th Amendment, which, after all, is not just the Equal Protection Clause, but is also the Due Process Clause and a number of other procedural values that point us toward a given result. I believe that Section 5 of the 14th Amendment embodies an expectation, not that government would withdraw from the social sphere and allow groups to order themselves according to their strengths, but that government would actively intervene to protect and ensure a substantive notion of equality, beginning with a fairly expansive view of civil rights. I've just published an article called Interpreting the 14th Amendment, 2 Don'ts and 3 Do's, and one of the common claims that's advanced about the amendment by judges and commentators is that it really was only intended to enshrine a very limited set of rights that are embodied in the Civil Rights Act of 1866. And these are formal rights of equality, the right to enter contracts, for example. I believe history shows that to be false. I think history shows the Civil Rights Act of 1866 was based on the 13th Amendment, and that the 14th Amendment had a much more expansive reach. And I think the framers foresaw a Congress that would step in and say to the states, this political practice, this social practice, this way of ordering is not acceptable within a 19th century republic. And they thought of the 19th century as pretty darn modern. There's a famous quote from Bingham. I always get a little choked up when I read it, because it's so, on the one hand, so visionary, and yet on the other hand, so sort of naive. And he says, in which he says, "It is the high heaven of the 19th century. Kings and tyrants hold their power with a tremulous and unsteady hand. The mighty heart of the world stands still, awaiting that final triumph of the right, foretold in prophecy and foreseen in song." And I think that something that sweeping was really what was envisioned at the time of the framing. So I think that equality is a substantive value, and that the procedural rights that are guaranteed alongside it are designed to make sure that we have a fair political system that abides by the rule of law. And I would like to see all those three things discussed more fully in society than they are now. And by the way, in a certain sense, in 14th Amendment values, the really radical gay rights decision is not so much Lawrence as Romer versus Evans, because if you go back and read that, it's about a society where government is available to all on equal terms. Lawrence, which, as a state, coming from a state where we were racked by repeated anti-gay initiatives, I thank heaven, the high heaven of the 19th century, for Lawrence, because it basically said, back off, leave gay men and lesbians alone. But I think there's much more content that we can all use in the vision that Justice Kennedy enunciates in Romer versus Evans.
I have two questions. First, when do you think the original Constitution was it like Calhoun and nullification, or was it before that? And then the second one is, why didn't the 14th Amendment framers just rewrite the entire Constitution, like call it another constitutional convention instead of just having one amendment?
Those are both really superb questions. I'm going to deal in more conclusory form than I would like to with the question of Calhoun and nullification. I think there's almost never been a point in American history where Calhoun theories have not been what they would say in Brooklyn, what they'd call ein bissel Meshuggah. I mean, that is just a little bit nuts. And I don't think that even the pro-slavery people who helped write the original Constitution thought of nullification as a genuine point. But I think part of it is that nullification was not going to be necessary. The South had so much going for it. They simply didn't foresee that the change in demographics and economics would threaten slavery's control over the Constitution, and so they didn't think that far ahead. As for the second question, tell it to me again.
Why didn't they just rewrite a new Constitution?
Yes, you have to understand the political situation was so dicey that the framers of the 14th Amendment figured that they had basically between December 1865 and maybe June 1866 to do what needed to be done. If they did not do it then, the thought was Johnson and the South would become resurgent. Johnson's plan was for the South to take part in the congressional elections of 1866. Under his executive order, the voting would be all white. No black voting was to be allowed in the South. The South would receive between 18 and 28 new members of Congress because of the abolition of the 3/5 rule. So that the advent of the new Congress after the 1866 elections would mean the complete triumph of the South, and there would be no more opportunity for reform. So they moved very fast, and they had to move. That's why they had to have one amendment. Originally, the plan was that there would be 5 or 6, but there simply wasn't time to do that. They had to have one amendment. They had to touch on the concepts that they needed to change, and they needed to get it before the people by early summer of 1866, a schedule they barely met. So, like most revolutions, it was only partially achieved in law. And what's remarkable when you look back is not that they didn't succeed more, but that they succeeded at all.
It seems like many commentators criticized the framers of the original Constitution for their grand talk about equality,
Right.
and then enshrining this principle of slavery into the document, and many of them being slaveholders themselves.
Right.
And I wonder if the framers of the second Constitution are susceptible to a very similar criticism for all of their talk about the equality and egalitarianness of a 19th century democracy. It was more than 50 years before women got the vote. It was a number of years before Wyoming, the first state that allowed women to vote, was even entered into the Union. And, at the time, no one was even considering allowing women to, in many cases hold property on their own or enter the professions on their own. I mean, isn't that just the same criticism? And why should we take their talk about equality any more seriously than we take Jefferson's?
Well, that's, first of all, we take Jefferson's talk about equality quite seriously. That's the interesting thing about these paradoxical prophecies. But your second point, I think, is really quite significant. There's a really wonderful chapter about it in this terrific book that you can buy on Amazon called Democracy Reborn. Because the fact of the matter is, the 14th Amendment represented a very, very painful betrayal. You say nobody was even considering. In fact, these ideas were very much considered at the time of the framing of the 14th Amendment. And the framers of the 14th Amendment, in part because of the haste that I just mentioned, and in part because of their own limitations, since the only people who had any operative role as opposed to intellectual role in the framing were men, simply did not understand how important it was to incorporate sex equality. Now, let me just say, Robert Dale Owen, the framer of the original draft, understood this perfectly well, and there was no language in his amendment that would have sanctioned the practice of male voting. Section 2 of the 14th Amendment does sanction that practice. Compromise was entered into once the amendment passed out of his control. Robert Dale Owen, one of the great male feminists in all of American history. But the women's movement at that time and the anti-slavery movement, up until the framing of the 14th Amendment, were not closely allied. They were the same thing, because the central claim of the abolition and anti-slavery movements was not simply that slavery is bad, it was that all human beings are equal, and that women's claim for equality in all those regards, in fact, legislative fixes to property holding and so forth had begun in the 1840s, was equally salient as the claim of the African American to civil equality and not to being enslaved. That betrayal is really one of the most painful parts of the story. There's an absolutely wonderful scene in the debates over the 14th Amendment in which Thaddeus Stevens is presenting the compromise draft and talking about how it will ensure equality. And a guy named James Brooks, who was a congressman from New York, he was a Democrat and very pro-slavery, basically, and kind of a clown, very lovable, but really an idiot, gets up and he says, "Oh, you're talking about equality. What about equality for women?" At which point the galleries just explode in applause because Douglas has made a deal with Stanton and Anthony, who are in the galleries, along with all of the key leaders of the feminist movement. He said, these guys have sold you out. You should be with us. And they had come there, and there's this applause, and the women in the galleries begin waving their handkerchiefs. It was hideously embarrassing, as well it might have been. As I'm sure you're aware, Stanton said at this time, if we let them do this, if we let them write this amendment with this fatal compromise into the Constitution, it will be 100 years before women are given the vote. And some of her allies said, no, the revolution will move forward. But in fact, she was a lot closer than they were. And one of the real poignant ironies of American history is that the first women's rights convention was held at Seneca Falls, New York, the first American women's rights convention in I believe in 1848, but it may have been a little later than that. And by the time women were allowed to vote in 1920, one and only one woman who had been present at that convention was still alive to cast a vote. She had been a young girl brought by her mother to see this historic occasion at Seneca Falls. She was the only person who lived to vote. So I think it's entirely appropriate to point out the failure that, of the 14th Amendment. But I would also say that promises to history are really, even when ambiguous, are really very powerful. And had the 14th Amendment failed, I don't think women would have had the vote even in 1920. I think we would have been in a situation much more involved with authoritarian concepts of government by elite than we were. And perhaps the progressive movement from which the movement for women's voting flowed would never have occurred. So we have to be fairly sober about American history. There's no point in American history where we have what Bingham said, the final triumph of the right, foretold in prophecy and foreseen in song. We never get there. We just keep moving forward.
I just was wondering, you mentioned like you're not taught much about the
I'm sorry, I didn't hear what I mentioned.
we're not taught much about the framers of the 14th Amendment.
Yeah.
And what we do learn about, the impeachment of President Johnson by that Congress is sort of, this cautionary tale of partisan politics going too far. Do you think, should there be a historical change on that?
Absolutely. I think that one of the mysteries that people debate very solemnly is why the 40th Congress felt it necessary to go forward with impeachment when it was perfectly clear by then, after the failure of Johnson's politics in the 1866 elections, that he would not be president after 1868, that it would be Ulysses S. Grant. So why did they go forward with this very divisive impeachment? And I think if you study the correspondence and if you study what was going on and what congressmen were hearing from the South in 1867, you realize that there's some weird parallels with our time, that the central struggle was not over Johnson's politics, but over his role as commander-in-chief of the military, which then at that time was still, under the Second Reconstruction Act, was occupying the South. Johnson refused to allow the military to intervene to protect black civil rights advocates, black educators, and white Republican, what we would call today liberals in the South, to protect them from an absolutely terrifying wave of violence being carried out. The Ku Klux Klan was founded in 1865. It was commanded by General Nathan Bedford Forrest. Lee had turned down command of the Ku Klux Klan. He said, "I wish you guys luck. It's a good idea, but I've got other things to do." Forrest said, "Let me at him," right? And the idea was well known in the South that after 1868, Grant would be president. They wouldn't have an ally in the White House. They decided to clean up, to cleanse their society of radical elements then. And a lot of the anti-slavery members of Congress thought, if we don't get this guy out yesterday, there'll be nothing left by the time Grant becomes president. And the anti-slavery political movement split because a lot of the anti-slavery senators felt that the legal precedent of impeaching a president over policy disagreement would be more destructive than allowing Johnson in office. I think history has a very ambiguous judgment on that, but it's not generally known, in part because the history of this period was rewritten between 1875 and 1920 by pro-Southern historians. David Brian Davis, who's a Lincoln biographer and one of the great Civil War historians of our time, wrote in 2000 that America is only now beginning to grapple with the South's ideological victory following the Civil War. And a lot of what we are taught about what was going on at that time is actually revisionism written by the sons and daughters of the slave owners who were trying to regain the honor of a region that had actually emerged from the Civil War with precious little honor of any kind. So that's my answer to that. I think probably people do have lives, I hope, though this is law school.
Buy the book. Buy the book.
We should break.
Thank you very much.
Yeah, buy the book.